Sir, how are you? I'm here. Perfect. That's it.
Sorry. Sure, no problem. We are blatantly in your way today. Sorry about that.
He's here from the county. I was told that Ronald Bryan's going to come over and read about it. Is he here?
Judge, they're coming.
They're on the right?
They're just on the hallway.
Okay. Whenever you want to go. Now let's wait till Ron gets in. Okay.
He's here. Good.
Oh, okay, go ahead.
Judge, may I have the sign sheet before you come out?
Do what?
May I have the sign sheet before you come out?
You guys want to talk about that? Bring it out, John.
Yeah, whenever you're ready.
I have filed.
Go ahead.
This is State versus Lincoln, Rutledge, one count of aggravated arson and one count of felonious assault against a police officer. The defendant, present here in court with counsel. Yesterday, in anticipation of him being released from the hospital, the state filed a motion to be held without bond, and is prepared with Detective Kennington this morning to present sufficient evidence to meet the statute that we cited in the motion.
Okay. Where's your detective? Oh, go ahead. Oh, do you swear or affirm your testimony in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, proceed.
Detective Ann Pennington, Florence Police Department, with the homicide squad, and also a member of the CERT team, which is the critical incident response team. This incident began on April 9th, 2016. SWAT officers were attempting to serve an arrest warrant on Lincoln Rutledge at his residence. Mr. Rutledge barricaded himself inside the residence and began firing gunshots at the officers. During this barricade, Mr. Rutledge fired gunshots several times, one of which struck Officer Smith in the head. Mr. Rutledge was eventually taken into custody. Officer Smith was transported to OSU Hospital, where at this time he's on life support and is not expected to survive.
Can you describe the incidents that happened the day before that caused the aggravated arson warrant to be issued that they were trying to serve?
The day prior, there's evidence to show that Mr. Rutledge went to the home of his wife. Shortly after he left the home, smoke erupted from the rear of the house. The house caught on fire. It was determined that this fire was an arson fire, and subsequently, with evidence that the arson investigators obtained, the arrest warrant was issued for Mr. Rutledge for setting the house on fire.
Has the wife expressed any concern in the police department prior to the fire and after the fire regarding her own safety should the defendant be out of custody?
Yes, there have been threats made to Mrs. Rutledge or Ms. Young in regards to her safety. He did, on one occasion, assault her. And yes, she has expressed her concern for her safety.
Are you aware of any circumstances where the defendant had knowledge that court authorities were looking for him and he fled the jurisdiction?
Yes, shortly after there was paperwork filed for Mr. Rutledge, he went to Missouri.
Your Honor, I have no issue.
Do we have a prior record?
No, Your Honor.
Okay. Counsel, on behalf of the client?
One moment, Your Honor.
Certainly.
Your Honor, may I ask the detective one question?
Go ahead.
Detective, you indicated that you acknowledged that Mr. Rutledge was in Missouri,
Yes,
but he then came back to Ohio, correct?
yes,
On his own.
I believe so. Yes.
No further questions for the detective, Your Honor?
Anything else you want to?
Yes, please. Your Honor, in response to the state's motion to request the court deny bail to Mr. Rutledge, Your Honor, we would submit to the court that this is a pre-indictment stage. Your Honor, we ask the court to overrule the state's motion for a few different reasons. Your Honor, again, as I just indicated, it's pre-indictment. Mr. Rutledge is not indicted on these charges at this point. He will then have a preliminary hearing date, presumably, or at least another opportunity to have bond addressed by a common pleas judge should the case proceed in that manner. Your Honor, Mr. Rutledge is 44 years old. He is still currently married. He's a graduate of Ohio State University. He's gainfully employed in the IT field for essentially since 1998. He's lived in the Columbus area, Lancaster, as well as Columbus proper for his entire life. Your Honor, to address the state's motion here, I do understand that there are factors that they place in the record. This time I'm not going to place specifics with regard to responses to the facts as being read. But the statute that Mr. O'Brien is citing here is that a judge must find by clear and convincing evidence that there are no release conditions that would preserve safety of the community or persons. Your Honor, I would submit to the court that since this is pre-indictment, there are things that the court could do in addition to setting a monetary amount for a bond. The court can issue a GPS monitor so that the court can be aware of where Mr. Rutledge would be. Additionally, there are several other things that the court could consider. Your Honor, we are just simply asking the court to consider overruling the state's motion and setting some amount of bond so that he may have the opportunity to bond out, not asking for a specific number. He does have no criminal record, no prior history of crimes of violence or anything. We're asking the court to take that into consideration, which the statute does address. The statute does indicate that the court should consider factors such as personal history when determining whether or not they're going to set bond. And I think that this case is appropriate for that, as the state has made their motion. I'm asking the court to take those considerations, and if you do, or if the court needs to review the statute, I can provide a copy of the statute to the court. In conclusion, I'm just asking the court to overrule the state's motion and consider setting some amount of bond.
Anything further from the state?
Only to indicate our Court of Appeals in a very similar case where an officer serving a warrant was shot upheld the denial of bond, and in that case the defendant had no record and was employed, and so I think it's almost directly on point.
Okay. I'm going to grant the state's motion to deny hearing under 2937.222. When I look at all the factors, I'm just not convinced that I don't feel that there are conditions of release that will ensure the safety of the public, given the circumstances that took place, officers serving a warrant, defendant not complying with the officer's orders to come out of the house, then the subsequent incident of a fire. That certainly put the public in jeopardy. There's a second case, an arson case, I understand, at some point will possibly be filed as well. I think when you factor all that in, the weight of the evidence, the history and characteristics with the concerns, family members' concerns about the defendant's mental state, I think when you factor in all of these things, clearly there's safety to the community that the court's concerned with, and I think the only way to ensure that safety is to deny bail. So there will be no bail.
Thank you, Your Honor.
April 21st at 9.
You hang with Lisa and Ron Cox. I'm going to go see if they're standby out there.
First,